let me welcome everybody very warmly to this side event on the occasion of International Justice Day, which, as you all know, was on Saturday, 17th of July. That's the day that the Rome Statute was adopted in 1998. We're very happy to do this side event on a very pertinent topic with an excellent panel, and very special thanks to the President of the Assembly for joining us and offering opening remarks. I also want to thank all our co-sponsors who are organizing this event with us. They are Argentina, Austria, Belgium, Costa Rica, the Czech Republic, Estonia, Luxembourg, Portugal, Spain, Sierra Leone, and Switzerland. So thank you all very much for doing this event with us. A couple of housekeeping remarks after the opening remarks in the panel discussion. We will have a Q&A and a discussion. Please use the Q&A function at the bottom of your screen. We will be collecting your questions during the panel, and we will ask them to the panelists during the Q&A section of our event. And please identify yourself with affiliation for this purpose. This event is being recorded for future viewing, and the recording of the event together with the chair's summary will be circulated thereafter. As a very brief introduction from our side, as discussions progress on how international law applies in cyberspace, it is of the essence that the Rome Statute of the International Criminal Court is part of this conversation. That this is the reason why 11 parties to the Rome Statute have created together a council of advisors on the application of the Rome Statute to cyber warfare. The council of advisors was composed of 15 international lawyers and assisted by 3 technical experts, as well as 1 representative of OTP, the Office of the Prosecutor of the Court, and 1 representative of the International Committee of the Red Cross. The council convened 3 times during 2019 and 2020 here in New York at our premises at the mission of Liechtenstein. The final report of the council will be presented during International Law Week in October this year, but we're very happy and honored to have 2 members of the council with us here today. Some of the conclusions from the report. Malign cyber operations, which have become an unfortunate and nearly daily occurrence, do not occur in a domain that is unregulated by law, but they are subject to various bodies of international law, including the Rome Statute. Realizing this potential of the Rome Statute means that such crimes could currently be investigated and prosecuted by the ICC, and the purpose of the Council of Advisors was to take a closer look at that and to illustrate the relevance of the Rome Statute as a living document. So with these brief opening remarks, it's my great pleasure to welcome the President of the Assembly of States Parties, Her Excellency Silvia Fernandez de Gurmendi, who will give a couple of framing opening remarks. Thank you so much, Silvia. It's great to have you here, and the floor is yours.
Thank you very much, Christian. Excellencies, ladies and gentlemen, greetings to all. I am thankful to the organizers for inviting me to participate in this event to mark International Justice Day, which commemorates the adoption of the Rome Statute of the ICC 23 years ago. When we look back at the adoption of the Rome Statute in the 90s, we cannot but feel a bit nostalgic of the negotiations themselves, as well as of the years in which they took place, which seem at a distance so much easier than the current ones in so many ways. We even tend to repeat that the adoption of the Rome Statute, one of the greatest achievements for the progressive establishment of a rules-based international order, would not have been possible today. Maybe, although we should also recall how difficult it was to make progress in the negotiations then, and that the adoption of the Rome Statute seemed impossible to many only hours before it happened. We should also remember that the 90s were not an idyllic time, but years of intense turmoil and extreme violence that resulted in genocide, war crimes, and crimes against humanity. Indeed, the creation of the two ad hoc tribunals was done in response to such atrocities in the Balkans and Rwanda, and that gave impulse in turn to the establishment of the ICC. The ad hoc tribunals, as well as its predecessors, the International Criminal Tribunals for Nuremberg and Tokyo 50 years earlier, were the product of their time in the 20th century, and very much a response to atrocities that had to a large extent already been committed. The ICC, created as the first permanent court of a general character, had a more ambitious goal, as it was not established as a response, but rather as a tool for prevention of future atrocities. Still, while the court was created for future generations, it was also very much the product of its century and of the atrocities committed then. This is explicitly said in the preamble, in which state parties indicate to be mindful that during this century, the 20th century, millions of children, women, and men have been victims of unimaginable atrocities that deeply shock the conscience of humanity. Since states were mindful of the past in order to prevent the future, it is indeed relevant to ask ourselves if the Rome Statute, a product of the 20th century, is indeed apt to prevent atrocities committed in the 21st century. The Rome Statute was adopted at the very early stages of global digitalization, when we could not predict the extension of changes that prevail in today's world. The change of century has been accompanied by huge technological innovations, which have had a profound impact on the way we work, we interact, and we communicate, and also on our individual and collective capacities to inflict harm through digital means and cyber operations. The nature of cyber operations presents unique considerations and raises important questions. Does the legal framework of the Rome Statute cover such operations? Are the definitions and elements of all or some of the crimes under the jurisdiction of the court apt to cover acts committed through such operations? Are the general principles of criminal law under the statute, and in particular the provisions related to intent and modes of responsibility, apt to cover such acts, not only from a legal, but also from a practical perspective? As we all know, cyber operations are notoriously difficult to trace and even more difficult to link to specific states or organizations. Some of them may involve multiple actors. Difficulties in attributing a crime not just to a state or a non-state actor, but to individual perpetrators may present serious challenges for prosecutors to meet the ICC's evidentiary standard of proof beyond a reasonable doubt. Linking the crimes on the ground to those who bear the greatest responsibility, often far away from the scene of the crime, is one of the main challenges for prosecutors at the court today. Such challenge will be for sure far more acute in the context of cyber activities and will also increase the needs for cooperation and information sharing. We need answers to these questions, so I commend the organizers of this event to use the opportunity of International Justice Day to reflect on the relevance of the Rome Statute in our digital era, and to present us to that effect with the findings of a council of advisors created by 11 state parties on the role of the ICC in the regulation of cyber warfare. This is an extremely important, timely, and indeed necessary debate in order to assess the relevance of the Rome Statute and more broadly, the relevance of international law and international criminal justice as we know it to contemporary problems. It is also a fascinating debate, so I really look forward to the presentation of the experts. I thank you for your attention.
Thank you so much, Silvia, both for taking us back to the days in Rome itself, and for taking us into discussion already by framing some of the questions that indeed have kept the Council of Advisors very busy when they met here. We're now turning to our panelists, and it's a great pleasure for me to welcome all of them. I really want to thank you for joining us today. Our first panelist is Ambassador Gert Alvert, who is the very newly appointed Director of Cybersecurity at Estonia's Information System Authority. Gert, of course, is also an ICC old hand in that he served as the legal counsel of Estonia to the embassy in The Hague, and he was the deputy of his mission here in New York. Estonia is currently serving on the Security Council, and it was the delegation that convened the first ever Security Council debate on cybersecurity. So wonderful to have you here, Gert, in a different capacity. It's very good to see you again. The floor is yours.
Thank you very much, Christian. And I would, first of all, personally like to thank you and the mission of Liechtenstein for bringing us together here today and shedding the light on this, not only today, but carrying the torch wider on this issue, both on ICC in general and also this new realm of cyber and the intertwining relation of the two. I am honored to address you at this event, marking the adoption of the Rome Statute 23 years ago, and to share this virtual panel with such distinguished international law academics and, of course, the President of the Assembly of States Parties. So thank you very much. Aside from firmly believing in justice and rule of law, Estonia is a strong believer in the potential and ability of new innovative technologies to benefit our societies. To us, it is like the air we breathe, these new digital solutions, and these technologies hold great promise for human and social development and welfare. They can allow us to live better and also to govern better, enabling better access to information, transparent and efficient government, healthier democracy, and greater protection of the rule of law. These are all in themselves preconditions for peaceful and secure societies. At the same time, these same tools and technologies can also be used to cause deliberate harm. And there are clear risks to human rights, democratic processes, and the rule of law, which have potential implications for international peace and security. Many of these hazards have already materialized. As a stark example, in the wrong hands, digital and emerging technologies have become convenient tools for political repression. Estonia remains deeply concerned about the practices that seek to assert excessive control under the pretense of ensuring national security, while disregarding international human rights law and the principles of an open, free, secure, and interoperable and reliable internet. During the last decade, UN member states have agreed on an effective normative framework for responsible state behavior in cyberspace. And Estonia holds a very strong view that existing international law, as you also mentioned, Christian, in the introduction, including the UN Charter in its entirety, international humanitarian law and international human rights law, applies in cyberspace. There are rules which apply. States are accountable for any acts committed contrary to their obligations under international law. We are encouraged and guided by the successful consensus outcomes of both the latest UN group of governmental experts, the GGE, and also the open-ended working group, which reaffirm the normative framework in this regard. And Estonia has been actively engaging in a range of international fora to try to help address the risks involved and to promote the uptake and use of emerging technologies in a way that is responsible, trustworthy, transparent, and also in line with the provisions of international law, including international humanitarian and human rights law, as I just mentioned. These efforts need to include a multi-stakeholder approach, embracing the private sector, civil society, and academia. And I'm glad to have academia here today to go in depth with this. In New York, Estonia, together with Singapore, co-chairs the group of Friends on e-governance and cybersecurity that seeks to inform of developments in this field. And I take the opportunity to thank our Singaporean colleagues in helping hold this torch high in the UN and in New York. Estonia has been striving to take forward the topic of cybersecurity also in the Security Council. And just last month, while I was still there with you in New York, Estonia, during our second presidency of the Security Council, organized the first ever Security Council open debate specifically on cybersecurity. This did not come sort of out of thin air. It took us 18 months of preparation to actually get everyone on board and to hold this debate in such a way. And it is, in our view, essential that the Council keeps up with contemporary security challenges and takes cyber threats into consideration. The open debate in itself, it presented an opportunity to raise awareness on the risks of malicious cyber activities, what they pose, and also to reaffirm the commitment of states to international law and the framework of responsible state behavior as key elements of conflict prevention and maintenance of peace and security in cyberspace. We are very glad that the meeting was constructive, with over 60 states and organizations contributing to this important discussion at a high level. One of the pertinent practical questions to be asked now is exactly how international law applies to cyberspace. And as a staunch supporter of international criminal justice, in particular the ICC, Estonia was honored to become a part of a group of countries to call into existence this Council of Advisors on the application of Rome Statute to cyber warfare. And we are very grateful to the experts that have participated in the group for their tremendous work, and to Liechtenstein for leading this endeavor. To conclude, I take the opportunity to point out that the NATO Cooperative Cyber Defense Center of Excellence based in Estonia is sponsoring the updating of the Tallinn manual from its 2017 2.0 version to 3.0. And this anticipated scholarly work by distinguished international law academics and practitioners will provide an updated objective restatement of international law as applied in cyber context. And all stakeholders have the opportunity to contribute to this process. To conclude, I look forward to hearing from the other esteemed panelists on their insights on the state intricacies of application of Rome Statute to cyber warfare. I thank you very much.
Thank you so much, Gert, and thank you for the leading role that Estonia has played in this field. In fact, for a long time, and you know, the open debate in the Security Council is certainly a highlight of that engagement. And thank you, of course, also for joining us as one of the states that set up the Council of Advisors. We're now passing to two members of our council. It's really great to have two members of the Council of Advisors here to talk to us about the discussions in the council and some of its findings. Our first speaker is Oona Hathaway. She is a professor of international law and counselor to the dean at Yale Law School. She has also formerly served as special counsel to the General Counsel for National Security Law at the U.S. Department of Defense. She focuses in her research currently on the foundations of modern international law, the intersection of U.S. constitutional law and international law, the enforcement of international law. And she's one of the outstanding experts on the law of armed conflict. Oona, it's really great to have you with us. The floor is yours.
Thank you so much. It's a real pleasure to be here, and it's been a real honor to be a part of these conversations, which have been really eye-opening and interesting for me. And I take heart in the fact that Klaus is coming after me, so we'll fill in whatever gaps I leave in summarizing some of our key conclusions on the crime of aggression. So my remarks are going to focus in particular on the portion of the report that talks about the application of the crime of aggression to cyber. And I just want to preface those remarks with a couple of points. First, the group was clearly acknowledged that most cyber operations, in fact, perhaps all cyber operations thus far, have not reached the use of force threshold, thankfully. So that we are talking about a set of operations that we believe probably haven't yet certainly haven't become common, may not have even taken place. But there clearly is the possibility for this. So I wanted to preface this because I think it's important to recognize that most of the operations that are happening in the cyber world are what are sometimes referred to as below the threshold operations. That is operations that are below the Article 2.4 use of force threshold in the UN Charter, and therefore not candidates for a crime of aggression. That's an area that remains to be developed. There is also a movement to try and think about what is the international law that applies to these below the threshold operations, in particular, building out the norm of non-intervention as a legal framework for understanding how that is a body of operations that are also regulated. So in speaking about the application of the Rome Statute, and particularly speaking about the use of force threshold, I just want to be cautious to recognize that this is thankfully kind of thinking ahead and trying to anticipate potential problems, but not that we believe or expect that this is a massive current problem that we need to be ready to address, but that we do need to be thinking about what the law is that might apply and how the Rome Statute might apply to it. So a few key starting points with regard to the question of the application of the Rome Statute, and particularly the crime of aggression, to cyber. There were some key agreements that were universally agreed upon in this quite diverse and interesting group of both scholars and practitioners. First is the Rome Statute clearly can apply to cyber operations. There was no disagreement on that point. There was universal agreement that in fact, the Rome Statute does apply to cyber operations, that cyber is within the scope of the international legal operations to which that can violate international law and therefore can be candidates for criminal prosecution under the Rome Statute. And then in particular, there was universal agreement that the crime of aggression can apply to cyber operations, that operations could be severe enough that they meet the standard for an act of aggression. So those are sort of key starting points. And even those key points, I will say, are really important to kind of get settled, that there was no disagreement on those key points, that there was universal adoption of those principles, I think is a really important starting point for the conversation, moving ahead and thinking about what kinds of operations, how might we fit out what kinds of operations might in fact violate the crime of aggression. So Article 8 defines an act of aggression, as you all know, as the use of force, use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state. And again, in talking about the word armed, in the past, there was some debate about whether an armed operation could apply to cyber, whether cyber is armed operations. The Council of Advisors agreed universally that a use of force, regardless of the specific weapon used, and including cyber, would satisfy the use of armed force element for what constitutes an act of aggression under Article 8. So there was no disagreement on that point. That was universally adopted by, again, this quite diverse group. The Council of Advisors did note that cyber warfare doesn't necessarily fit into the traditional kinetic, state-centric, territory-focused notions of acts of aggression, but there's still many ways in which a cyber operation could fit within the acts of aggression in Article 8 bis of the Rome Statute. It encapsulates, and Article 8 bis, moreover, encapsulates a non-exhaustive list of acts that amount to acts of aggression. And so we're not necessarily limited exclusively to those that are listed within the existing Rome Statute. And the next question that the council thought about is how broadly could Article 8 bis be interpreted to include cyber operations within its purview, and what kinds of operations would satisfy the armed force threshold. There we turn to the question, there was widespread agreement that in order to meet the threshold of a manifest violation of Article 2.4, which is what's required for the crime of aggression, you look to character, gravity, and scale of the operation to determine whether it meets the act of aggression. So again, these are points in which there was widespread agreement group. The question is then how serious far-reaching must the operation or the consequences of a cyber operation be to meet that threshold? And here we had some areas of agreement and some areas where there remains room for further development as we continue to get a better understanding about the kinds of cyber operations that are out there. So it's clear that a manifest violation is a breach of the prohibition of the use of force, where it's a grave violation with serious consequences. So what's sufficient to meet that standard? It has to be very serious and unambiguously illegal, and obviously qualify as a use of force, but it has to be not just any use of force, it has to meet a kind of further threshold in order to qualify as a crime of aggression to be a manifest violation of the UN Charter. So what meets standard? There was agreement, pretty universal agreement, that a cyber operation that results in loss of or injury to human life would reach the level of a manifest violation of the prohibition of use of force. So an operation that leads to somebody to die or be injured, physically injured, is likely to be a candidate for a manifest violation. There was some disagreement as to whether an operation that merely causes physical damage or destruction of property alone was sufficient. And that I think is something that remains to be developed over the course of conversation, not just about the application of the Rome Statute, but about what constitutes a use of force under Article 2.4 when we're applying it exclusively to cyber. There were certainly many of us, and I will admit I'm in this camp, that think that we should be limiting certainly a manifest violation of the Charter to loss of life and physical harm to people. There are others who think, well, that's maybe too short-sighted or too narrow, that there could be a sufficient instance of significant property damage that would be enough by itself to step over the line. And what's striking about this conversation is that cyber really is one of those unusual weapons that makes it possible to destroy a lot of property, obviously a lot of data, but also actually physically destroy a lot of property without killing anyone. That isn't true with kinetic weapons. That isn't true with bombs. That isn't true with traditional weaponry. You couldn't, generally speaking, destroy a city without killing many of the inhabitants or significant numbers of them. Cyber is one of those strange weapons in that it's possible to do a lot of destruction and potentially not kill anyone. And that's why we're confronting these challenges really for the first time, in a sense. These kinds of problems are ones we have not had to debate and discuss. And so we're in the midst, I think, of this kind of conversation. And that's part of what's exciting and interesting, I think, about this project, is it opens the door to our thinking that through. One thing I'll note is that there was a cautionary note sounded by several members of the group that we want to be careful not to excessively lower the threshold as to what counts as a violation of Article 2.4 of the Charter, because once you have a violation of Article 2.4 of the Charter, the US position at least is that the Article 51 threshold for self-defense and the Article 2.4 threshold for use of force are one and the same. And thus the US position would be, if there is a use of force under Article 2.4, there's an Article 51 right to respond, and not necessarily in kind. Responses under Article 51 do not have to be equivalent, they have to be proportionate to the threat, but they don't have to be equivalent in kind. So it doesn't have to be cyber operation for cyber operation. So if you have a cyber operation that counts as an Article 2.4 violation, and we've lowered that threshold, you could have someone argue that that is sufficient to trigger Article 51 right to respond with, say, an airstrike. And so this is part of the cautionary note for not ratcheting down the threshold so far to achieve certain ends, that is regulating it through Article 2.4, calling it illegal, an illegal violation of the UN Charter, and making it potentially qualify for the Rome Statute without thinking about the consequences on the other end, that you might be triggering a right to lethal response through military operations. And unless you're bearing that in mind and thinking this through as we're working through these difficult questions, you're not, I think, progressively developing the law in ways that are ultimately in the best interest of the international community. So I will pause there. There's much more to talk about, but Klaus is coming after me, so I'm sure he will fill in some of the details, but hopefully that gives you a sense of where the conversation went. We had a lot of areas of really important substantive agreement. And then when it comes to developing some of the fine-grained details of exactly what constitutes a manifest violation, there were, and it's reflected in the report very carefully, some areas in which we didn't have necessarily settled agreement, but I think that's appropriate given where the law is right now. And we're seeing that kind of begin to develop, and this project is part of that development. So over to you, Klaus.
Terrific, Ona. Thank you. Thank you so much. Indeed, while the Council did look at the Rome Statute as a whole, it had particularly deep and detailed discussions on the crime of aggression, which was also for us as a delegation one of the reasons why we took this up in the first place. And indeed, the questions were both fascinating and challenging. And I think Ona's remarks have given you a bit of an idea of that, and you'll get more of that now from our next panelist, Klaus Kress. Klaus is a professor of international law and criminal law at the University of Cologne, and also the director of the Institute of International Peace and Security Law. More importantly, for the purpose here, of course, Klaus is one of the outstanding experts on international criminal justice worldwide, and has been working on ICC issues for a very, very long time, has been part of term delegations to ICC meetings since '98, and he was for us an extremely important presence and support at the Kampala Review Conference, of course, where we dealt with the crime of aggression in particular. More recently, he has been appointed ad hoc judge to the ICJ case, in the case of Gambia versus Myanmar, on the application of the Genocide Convention. And of course, as you know, Klaus joined the Council of Advisors, and it's wonderful to have him here. Klaus, thank you for joining today, and over to you.
Thank you very much, Christian. Such a pleasure to be on this panel with distinguished colleagues and old friends. And as the president of the Assembly of States Party, as Sylvia has rightly said, it's a fascinating debate. It has been one, of course, for reasons of the subject matter, and Ona and also the ambassador have given us already a taste of it, but I would like to add, Christian, it has also been most thoroughly enjoyable because of the good chemistry within our group and your wonderful hospitality as usual. Let me perhaps place our work a tiny little bit in context first. We have not been the first reflecting, contemplating, discussing about the applicability of international law to cyber activities, as the ambassador informed us and you informed us at the beginning. There was the Tallinn Manual 2.0 being part of the conversation. It has been mentioned, drafted by scholars and independent actors. There was governmental work at the collective level, the UN level. The UN group has been mentioned. And there has been, over the past years, an increasing series of individual state pronouncements on so to speak, their understanding of how international law applies to cyber operations. So quite a rich material already being out there. So where is, if you may call it that way, our distinct place? So where, in what sense, most importantly, this report, which will soon be before the public, might ideally make a contribution? I think that the work so far, systematically speaking, has been focusing most on the conduct rules of the international legal order and on certain legal consequences, those legal consequences which form part of the state responsibility framework. But if you look at Tallinn, also the materials of the governmental work, and also most pronouncements by individual states, the distinctive corpus of international criminal law was largely absent. And there is nothing to complain about it. There was so much new territory to be covered. Obviously, a choice had to be made. But it was, so to speak, and here I wholeheartedly agree with those who have initiated the process. It is quite a considerable lacuna to be filled, and hence the need to look more closely on international criminal law. And that's the very purpose of this report. As Ona has told us already, this report will start with crimes against humanity. And although there will be no disagreement whatsoever in my remarks with those put forward by Ona, I will, and I do this quite deliberately, re-emphasize a number of points because they are so important to my mind. And I would like to premise my remarks on the crime of aggression in the following way. It comes on top of our report, the observations on the crime of aggression. I don't think that this was done with a view to revitalize the famous Nuremberg statement that the crime of aggression, formerly crimes against peace, is the ultimate or the supreme international crime. That's not the key message, but there are very good reasons to have the crime of aggression coming first. The first reason being, I think we are still in a process looking at the ICC, where the ICC and its personnel is internalizing the fact that only quite recently the court's jurisdiction over this crime has become activated, whereas the other core crimes under customary international law are long there and form already part of an emerging body of practice. So this report in that sense is also meant to contribute to this process of internalizing that the crime of aggression, born in Nuremberg and being at the time at the center stage, is now part of that body of international criminal law to be applied by the first permanent international criminal court in history. And then secondly, there have been doubts expressed about whether or how clearly cyber operations were at all covered by this newly adopted definition that Ona has already mentioned in Article 8 bis. I recall, for example, the proposal made by Beth's very eminent American colleague and then former chief negotiator by the United States, David Scheffer. He proposed to revise this newly adopted definition of the crime of aggression in order to make it explicit that as he called it, cyber actions are covered by this definition. So that statement by an eminent scholar and practitioner in international criminal justice makes it apparent that there is something to clarify. And with that in mind, it is indeed fundamentally important, as Ona mentioned already, that this group, and not just parts of it, but that this group unanimously said and stated, cyber actions may amount to acts, state acts of aggressions, as they form a cornerstone element of this criminal law definition. And they do so for, or they may do so for two reasons. First, because the lists of acts, as Ona said, is not exhaustive. And it bears making that point because while it was consensual in our group, as Ona said, it is by no means consensual outside this group. There are diverging views, and that this group, and Ona very correctly said, diverse in certain respects, that it concurred on this one is quite helpful. But also the group said that a number of those explicitly mentioned acts can by no undue stretch of interpretation cover cyber operations. And this is basically so because our group has, and I think it is fair to say, consolidated a clearly emerging trend on the application of the concept force, armed force in the cyber realm, meaning the effect-based approach to that concept of law, rather than requiring that certain means, certain specific weapons are defined. So this is not a new statement, but it is still at this juvenile stage of the debate, I think quite helpful to have reports of a group like this one confirming a sensible trend. And then very, very importantly, and I really wish to re-emphasize this very strongly, what Ona said, the group was keen in emphasizing the need for a narrow approach to the concept of armed force, highlighting the need for being very reluctant to go beyond physical destruction. This even with respect to concepts such as critical infrastructure that are floated quite widely without, as of yet, having been really clearly defined. And the concern behind it, and here again, Ona hit the point very, very correctly. There was a strong concern among members of the group not to open the gateway to the invocation of the right of self-defense under Article 51 too hastily, too early. And with all those debates about the right of self-defense ongoing, I think it would even be worth to have 4 or 5 members of our group making that very point again and again. With respect to the threshold, the particular threshold of manifest violation, here, of course, our group has covered new territory, so to speak, because as I said, most of the other documents that are already available have not dealt with international criminal law, the crime of aggression, rather with use of force and the right of self-defense. So it was here that the report was asked to make some not necessarily innovative contributions, but pronouncement on not so deeply covered territory as of yet. And the group has emphasized, as Ona said, the stringency of that threshold. And Beth, who was very much part of the negotiation will recall this as a loyal, as a loyal recording of the spirit of those very sensible negotiations. This threshold, the manifest threshold, was, so to speak, the key component to reach compromise on the substantive definition. And even, I think, very usefully, the report stresses that it is important to distinguish this concept of manifest violation, act of aggression and manifest violation from other, so to speak, proximate concepts. And the report said there is also need to distinguish it from the concept of armed attack, for example. It is not the identical legal context, even though the notions are situated in proximity. And Ona has dealt with it in more detail. I will perhaps, in finishing on the crimes of aggression, just capture one formulation in this emerging report, which seems to me to capture the essence on the threshold best. The report states that because Article 8 bis requires the attack qualifying as an act of aggression to be a manifest violation of the Charter of the United Nations, a cyber operation without loss of or injury to human life or large-scale physical destruction may only rarely lead to the prosecution for the crime of aggression. So you find in this very careful formulation a degree of openness that reflects differences on which Ona has spoken in greater detail. But this is the essence, and an essence that emphasizes, and I think duly so, the stringency of the threshold. Let me conclude this short introduction with a few observations on the other crimes, in particular those of war crimes and crimes against humanity. And their importance is partly due to one aspect, so importance beyond the crime of aggression. The crime of aggression is defined in a way which is quite state-centered and which makes it difficult to cover the activity of non-state actors. And it is precisely here that war crimes, in particular those committed in non-international armed conflicts, and crimes against humanity, pursuant to a non-state organizational policy, will cover some ground that the definition of crimes against crimes of aggression cannot cover. And in that respect, it was, I think, and I hope, very useful that the report extends beyond aggression and covers all crimes under customary international law listed in the ICC statute. On war crimes, the most important point probably, and very much in line with what the ambassador told us at the beginning, the report clearly confirms the applicability of IHL, of international humanitarian law, to cyber operations. No ambiguity in that respect. The report also does not rule out that cyber operations can, even by itself, trigger an international or a non-international armed conflict. However, here, as in the context of the use of force, self-defense, manifest violation, the report is very cautious to strengthen the need for thresholds. And in that respect, in particular, the threshold for the existence of a non-international armed conflict, a threshold resulting from the two well-known criteria of a certain intensity of the armed force and the organizational requirement, in particular that pertaining to non-state actors. So in that respect, the report agrees with the Tallinn Manual that cyber operations alone will amount to non-international armed conflict only in exceptional circumstances. And I think this is a very important statement for many policy consequences. There is, however, not invariably complete congruity between what we did and the Tallinn manual. There are, and I just want to highlight in the limited time, two aspects where our report to a lesser or greater extent adds nuance to what Tallinn has proposed. First, when it comes to one key legal term of the law of the conduct of hostility, the term of attack, but now not in the sense of armed attack, but in the terms of military attack under the conduct of hostility paradigms. Here there was a broad sense of consensus within the group that more is covered than just physical destruction, that also the loss of functionality of physical object can be covered by this key notion of attack. And then also particularly important in the cyber context, the group has taken a fairly open mind to the possibility of qualifying data as civilian objects that can form the targets of an unlawful attack, and then of course as a consequence also of war crimes. Last point, crimes against humanity. Here of course crucial to distinguish between the contextual elements and the underlying offenses. The report will deal with both of them, but my concluding remark is on the contextual elements only. The report states, and I think this again is fairly uncovered territory so far, the report states that it is conceivable that cyber operations may amount to a systematic or widespread attack against a civilian population. Of course, here again, the threshold is significant, but the report states the possibility as such is conceivable. I think one of the most interesting conversations we had, Ona, with respect to crimes against humanity was this question, what about cyber operations, even repeated ones, numerous ones, which do not cause physical damage, but only non-physical one, psychological one, mental one? We all agreed there is not much precedent so far in bringing those type of action within crimes against humanity. On the other hand, it is also clearly acknowledged by existing jurisprudence that, for example, mental harm, the causing of mental harm, is indeed covered by certain of the underlying offenses. And this is why we also cautiously adopted an open mind in that respect. So here you see, Christian, that the report cautiously, quite often, because there was due reason to be caution, has tried to, as comprehensively as possible, without certainly exhausting all the details, has tried to apply also the other crimes under the ICC statute to these types of harmful operations. Thank you.
Thank you so much, Klaus. Indeed, it was very important for us to take the Rome Statute as a whole and take a comprehensive look at it. And I'm grateful to you for having given our audience a bit of an idea of how that has played out. While of course you also went pretty deeply into the crime of aggression questions, which are particularly, I think, both challenging and fascinating and highly relevant. And of course, in that sense, you've also taken us back to the Kampala discussions to an extent. So many thanks to you. And with this, this gives me a very good segue to go to our last speaker, Beth van Schaack. Beth is currently Professor of International Law at Stanford Law School. She has previously served, among other things, as the Deputy Ambassador at large for war crimes at the US State Department, and was also a member of the delegation to the Kampala Review Conference. More recently, she has also served as the co-chair of the American Society of International Law Task Force on policy options for US engagements with the ICC. Beth, wonderful to see you here. Thanks for joining us. We very much look forward to your comments from somebody who was not on the council, but who knows these topics very, very well. So very much look forward to hearing from you. Beth.
Great, thank you so much. First, for including me in this important and timely conversation, and also for the really insightful remarks of my colleagues. I really have to congratulate the Council of Advisors on producing such an important and astute report. It really covers a lot of ground. I personally learned a lot, even though I'm in many respects immersed in these issues, but it really promises to inform our collective thinking on this important topic, even as cyber attacks increase in number and intensity as we're meeting here today. So I think it was Klaus who mentioned that much of the work around cyber operations has focused on the question of state responsibility. And that has been in turn really dedicated to the idea of attribution. How do we attribute the acts in cyberspace to a state when you often have degrees of deniability because there are non-state actors who have been recruited in order to launch these various attacks? This issue really bedevils the field, I think, but it's less pressing when it comes to individual criminal responsibility and the realm of international criminal law. As has been discussed, many of the crimes, with aggression excluded, can be committed by non-state actors against non-state actors. There's no requirement necessarily to demonstrate that a state was responsible for launching, initiating, ordering, funding, or in any way organizing a particular cyber attack. And so international criminal law offers a really interesting way to think about how to enforce these norms and how to attribute responsibility and ensure accountability, all also with an eye towards increasing the ability of international law to act as a deterrent within international relations. Now, when it comes to international criminal law, I do think it's relatively straightforward to fit what we might call cyber-enabled international crimes within the existing framework of the Rome Statute. So this is where cyber means are used to commit crimes, so long as the incidents otherwise meet all the elements of the treaty's definition of these crimes, and that the matter itself can satisfy the various jurisdictional requirements. I think it is more difficult, and this has been clear from some of the previous remarks, to deal with cyber-only exchanges that may cause only digital damage or may only disrupt service or cause economic harm or harm to property or incapacitate systems without actually physically harming human beings. And so here I think we really do have to engage in a little bit of an act of juridical translation, applying provisions that were not necessarily drafted with cyber activities in mind to modern forms of statecraft and warfare. And this is where I think the Council of Advisors have really done a fantastic job of thinking creatively, but also within the bounds of the Rome Statute, to apply this statute, as the President has said, as a living document to contemporary forms of state interaction. So because a lot of attention has already been spent on aggression today, I thought I would focus my remarks a little bit more on the other crimes within the ICC statute, the so-called core crimes that encompass war crimes, crimes against humanity, and genocide. And so the one element that has been pointed out is that the crime of aggression has really still been defined in terms of state action. It envisions a state as a perpetrator and a state as a victim. This is not the case necessarily with respect to war crimes. We do have the concept of an international armed conflict, but the Rome Statute has gone a long way towards collapsing the distinction between these two categories of conflict. almost all war crimes that we envision within an international armed conflict can also be committed and thus prosecuted within a non-international armed conflict, but not entirely. And I think cyber operations really bring to the fore the way in which the drafters of the Rome Statute still made distinctions between these two categories of conflict. And many of the crimes that might be the war crimes that might be particularly implicated by cyber operations are not necessarily prosecutable when they're committed within a non-international armed conflict. There have been some really important new amendments that have started to better harmonize these two bodies of law when it comes to war crimes that may be prosecuted in an international versus a non-international armed conflict, but it hasn't gone far enough, I don't think, and has still left a number of crimes only prosecutable before an international conflict. So what are these? Number one, we have the idea of extensive destruction of property, not justified by military necessity. This is articulated as a grave breach of the Geneva Conventions and thus prosecutable in an international armed conflict. That provision doesn't exist in the Rome Statute vis-a-vis non-international armed conflicts. Intentionally directing attacks against civilian objects, which, as Klaus mentioned, could potentially be interpreted, and I think it should be interpreted, and I really commend the Council of Advisors from departing from the Tallinn Manual here, but could be interpreted civilian objects to include personal data that we, about us, including bank records, etc. Launching an attack with the knowledge that it will cause incidental harm to civilians that's clearly excessive in relation to the concrete and direct military advantage anticipated. This crime also is only prosecutable before an international armed conflict and not a non-international armed conflict. Now, to some extent, maybe this is of no moment because so often cyber crimes are committed or cyber operations are committed between states in state-to-state interactions. But here, however, we come back to this problem of attribution. There must be a nexus between the war crime and the underlying predicate conflict. And so unless a cyber operation can be somehow linked to a state that's involved in an international armed conflict, it may be difficult to prosecute it under the Rome Statute. I should emphasize that all of this conduct is still prohibited by IHL, the law of armed conflict, but the question is whether it can be prosecuted under the Rome Statute before the ICC. International humanitarian law and the law governing war crimes require the existence of this conflict as a predicate. As we know, crimes against humanity are somewhat different. Their contextual predicate is a widespread or a systematic attack against a civilian population. And as Klaus has mentioned, one can imagine cyber operations satisfying both of those predicates. There may be a cyber operation that would initiate an armed conflict, thus triggering the applicability of IHL and thus triggering the ability of the ICC to prosecute the range of war crimes within the Rome Statute. You could also imagine a cyber operation constituting a widespread or a systematic attack against a civilian population, thus triggering the ability of the ICC to prosecute crimes against humanity. And here, these thresholds are incredibly important. And the ICC, when and if it ever considers a situation where we're dealing with kind of cyber-only operations, will have to think carefully about how to apply the existing thresholds to these new circumstances. Interestingly, in the past, victim states have largely responded to cyber attacks, cyber operations through non-kinetic means, such as countermeasures and countermeasures somewhat in kind. Ona mentioned this point in her remarks. It thus may be harder to conclude that a cyber attack would trigger the existence of an armed conflict between states. But this may change, of course, as cyber operations increase in frequency and impact. I do think, putting the contextual elements of crimes against humanity to the side, I do think it can be somewhat tricky to apply the constitutive acts of crimes against humanity to cyber-only events. I think it's possible, and I think the report does a really excellent job, and Klaus mentioned this at the end of his remarks, at conceptualizing how psychological harm that might, for example, be prosecutable as an act of torture or an act of persecution on discriminatory grounds against civilians within a particular society. These could be, cyber-only acts could be prosecuted as these particular acts, but so many other enumerated crimes against humanity are really focused on violations of physical integrity of individuals. And so unless you have physical harm to persons, which of course we know cyber operations can do, for example, the destruction of critical infrastructure, hospitals, disrupting the food chain, disrupting the water distribution channels, disrupting our ability to keep our food fresh, for example. All of this could cause very serious harm to human beings and human welfare, and thus could more easily fall within the constitutive acts of crimes against humanity. But cyber only, I think we're going to have to do some additional thinking about how the psychological harm, feelings of cyber intimidation, cyber harassment, etc., might fit within the elements of crimes against humanity. I found, again, when it comes to genocide, we tend to think about genocide as being committed through mass killing, but it's important to recall that the Genocide Convention and then all subsequent definitions of genocide in the international tribunals, which have basically reproduced the convention definition, all include acts that fall short of mass killing. So the creation of conditions of life that would lead to the destruction of a protected group, or physical and mental harm, again, committed with the intent to destroy a protected group under the Genocide Convention. One can imagine the use of cyber means to carry out these other acts of genocide. And in fact, it may be somewhat easier to use these more gradual approaches where there's a degree of deniability involved to try and destroy a protected group, rather than undertaking large-scale kinetic activities or utilizing death squads, et cetera, which will bring a lot of attention to the perpetrator group. And I think thinking about the way in which cyber means could also contribute to the commission of genocide has really come to the fore in the situation in Xinjiang, where we see massive cyber surveillance, harassment, intimidation, and the use of cyber means to identify individuals and then bring them into a system of forced labor, arbitrary detention, torture, etc. We can imagine that the Rome Statute and the definition of international crimes within it could reach those sorts of activities with a high degree of cyber enablement. Now, all told, I think the Council is exactly right, and the remarks today have been completely on point, that the Rome Statute can be made to apply to the cyber context. But I do think that there are some discrete amendments that could improve the prospects for a successful prosecution and a comprehensive prosecution that could include the whole range of harms that might be committed within a situation in which the Rome Statute would be activated. So most important might be to finally activate the provision addressed to employing means or methods of warfare that are inherently indiscriminate, thus and extending that provision to non-international armed conflicts. That provision exists already in the text, but it's dependent upon an annex, and that annex has never been populated. And so as a result, the Rome Statute does not allow the ICC to prosecute purely indiscriminate attacks. In other words, attacks that are not directly focused on a military objective. And we know that various forms of cyber weapons, if we can call them that, malware, etc., are often designed to spread through a system indiscriminately. Although we should also note that that's not necessarily inherent. The Stuxnet worm, if you remember that, which actually was released the summer that the Kampala amendments were being drafted, and so was only just basically in the contemplation of drafters. It was deployed on a closed system, and it also contained a do not infect indicator that limited express. So it does suggest that cyber attacks can be discriminate attacks, but we know that so often they are not discriminate attacks. And so activating that provision within the Rome Statute would go a long way towards enabling the ICC to prosecute these crimes. Now, in closing, I'll say much in this area really hinges on, I think, how the court interprets an entirely different provision within the Rome Statute. So not Article 8 bis, 8, et cetera, dealing with the international crimes, but rather Article 22, which contains a very robust articulation of what we call nullum crimen sine lege, no crime without law. This is the principle of legality that says that acts should not be prosecuted as crimes unless the perpetrator had fair notice that they might be subject to prosecution, so that they can conform their behavior to the law if they're inclined to do so. Given that cyber attacks were not in contemplation during the drafting of the Rome Statute, or even really just on the horizon in the drafting of the Kampala amendments, this strong nullum crimen provision within the Rome Statute might convince the judges to refrain from adapting too broadly the existing text to this new context in the absence of further guidance from the ASP, on the theory that today's defendants could not have anticipated that the dissemination of malware on a government system, for example, might render them subject to prosecution for crimes against humanity. The ICC statute and the ICC is the first international tribunal to be expressly governed by a very strong nullum crimen sine lege principle like this. The earliest tribunals, and I've written about this extensively, did not feel themselves to be fully bound necessarily by the principle of legality. They were more comfortable, I think, with adapting language and with using general principles of law and customary international law to identify international crimes. The ICC may be in a different posture here. Now, we haven't yet had occasion for the ICC judges to interpret this provision. We've started to see, however, some inclinations of a willingness to think creatively about how to expand the text of the Rome Statute to new circumstances that may not have been contemplated. I'm thinking in particular of the Ntaganda decision, where the court found that in-group harm, so sexual violence committed against girl and women soldiers within non-state actor armed groups, could be prosecuted as war crimes. That is a departure, I think, from standard approaches to war crimes, and reveals a willingness of the ICC judges to sort of think beyond the inherited wisdom and to apply the Rome Statute to modern situations. So in closing, I think, and all told, it's very clear that the ICC will not be the exclusive, or maybe not even a frequent forum to address the harms associated with cyber attacks, but there's no question that it can be part of a coordinated prevention and accountability system at the international and domestic level that will involve civil claims and claims of state responsibility, and also criminal charges against responsible individuals. The report is really just such a tremendous contribution to the field. It offers a great set of blueprints for the judges and the prosecutors to think about how to charge and prosecute cyber operations as international crimes when all of the factual and jurisdictional predicates exist. So thanks so much again, and I really look forward to our discussion.
Thank you so much, Beth. Really terrific, and thank you for studying the report in a relatively short time, and for bringing your own thoughts to it, both as far as possible treaty action within the Rome Statute, which is something we did not contemplate in the Council's discussion. So our approach was really, let's look at the Rome Statute as is, and let's take the premise that international law does apply in cyber, and what does that mean. But we certainly did not exclude that either, and I think your ideas are extremely important, and I really appreciated your comments on Article 22. So we have a little bit of time for discussion, and I really want to encourage people to use this time according to the modalities that I've described at the very beginning. So please ask your questions in the chat box, and if you want to have them addressed to a particular member of our panel, let us know. Our idea in convening the council was certainly not to try to give you all the answers, but in a way to frame the questions in a more in-depth manner. I think the council has been very successful in doing that, but we're also very mindful of the fact that this is the beginning of a conversation that we want to continue after this, but we're hoping to make a very good first step contribution to that, and we look forward to the formal launch of the report that will, as I said, happen in the framework of the International Law Week, which I believe is the most suitable moment for this. Let me also take this opportunity to thank my team, in particular Sina Alavi, our legal advisor, who has done really tremendous work on this and is still working on finalizing the report. So I really want to thank Sina and the rest of our team for the work that they have done. So Gert, I saw that you raised your hand, but I'm not sure if you meant to raise your hand or if that was a cyber malfunction. Do you want to comment, because I saw that you raised your hand in response to a comment from Beth. You want to speak briefly? Gert would be happy to give you the floor.
Nothing to add. I think that the discussion has been exciting and very thorough. So from my side, simply a big thank you to all. Thanks.
I'd
Great.
like to raise a question. Christian, if
absolutely.
While our audience is considering, I didn't raise this in my remarks, but I did think the report elided over somewhat the question of armed attack. I appreciate where you landed, and I think it's probably the right outcome. But as someone coming fresh to these issues, I caught on that, and I was trying to think through what work the word armed does. We have it when it comes to armed force, and we have it as a modifier for armed attack. And it's in some of the core international law documents and was obviously drafted with kinetic means in mind. And so I'd be really interested in hearing kind of a little bit more about the thought process on how you can connect the idea of an armed attack to a cyber operation. Again, I think you're right, and we obviously need to adapt to these new means and methods, but the report might benefit and our audience might benefit from a little bit of clarity on that.
Okay. Ona, I'm sure you want to say something on this.
Sure, I'm happy to say a quick word. I think one thing I will say is that we concluded that armed was not by itself limited, what did not exclude cyber, as I mentioned earlier. So armed, and that has been a discussion in the past as to whether cyber could be an armed act or an arm that counts. So as to, for instance, the use of the term armed attack in Article 51, does it meet that threshold? That's not directly relevant to the crime of aggression question, but it's relevant. It's relevant in the sense that that how do we apply this pre-existing international law standard to cyber, and what kinds of actions are sufficient to meet that threshold? We didn't delve into that in a great deal of detail because we were really primarily focused on this question of what's a manifest violation and whether it was sufficient to meet the threshold for a crime of aggression and therefore an act of aggression. I do think there is some space for more explicit discussion about the question of the difference or similarity between Article 2.4 and Article 51. The sort of shadow of the US position kind of hangs over this, which is it has a kind of odd position that the thresholds are the same, which is distinct from what the rest of the world, pretty much the rest of the world's position, which is that the Article 2.4 threshold is a lower threshold than the Article 51 threshold. It's true we didn't delve into that. I think just there's limited amount of time, but I think that that's an area where I would love to see further development and engagement and maybe even some room for the Biden administration to make some progress by maybe revisiting that question. And I don't think that's it by any means off the table. And if it did so, I think it would open up some more space for international debate and discussion on this question that I think has been a little bit foreclosed by the fact that the US has this fairly distinctive view.
Thank you so much, Ona. Klaus, you want to add to this? We have also now engagement from our audience, but I'm sure you want to add something to this. Klaus.
In that case, let the audience go first. If time suffices, I would like to comment on Beth's remarks a little bit later. Okay,
that sounds terrific. So we'll go to our Q&A, and the first question is on attribution. And the question is simply if the panelists would be willing to speak, elaborate a little more on challenges and possibilities. The question is from Noah Weisbord, whom we know, of course, very well, who's part of our discussion. So Klaus, maybe you want to take this, or Ona, one of the council members.
I'm happy to start and then can add. So on attribution, there are, of course, always the two levels. What's the law? And then how is this law applied, in particular, in a judicial proceedings? With regard to the law, I believe the report has taken quite an unrevolutionary perspective. It was our mission to apply the law as it exists. We did not feel that we had the task to reinvent the existing attribution rules. So we have, as I think we should, we have dutifully referred to the elaborate case law of the International Court of Justice, the two leading cases on attribution, which are well known, Nicaragua and then the Bosnian genocide case. So we have highlighted that under this existing jurisprudence, the attribution threshold is rather stringent. We have noted the somewhat different line of jurisprudence in international criminal justice when it comes to delineating international and non-international armed conflicts. So overall control, effective control, I guess most of the audience will be familiar with it. We have highlighted that in a little bit more open textured but important paragraph, that there is a question, an interesting question, how this general attribution standard interrelates with the specific act of aggression listed in Article 8 bis 2, and of course taken from Resolution 3314, because there is, in addition to this alternative, the sending of certain non-state actors to another state for the purpose of using armed force, also this famous language of or the substantial involvement therein. And well, the report has not dealt with it at length, but it has noted that this will be a very interesting and important avenue for the judges to look more concretely how this will play out. And then, of course, with respect to the application of this standard, we could not avoid stating what President de Gourmendi has already mentioned, that the law may be fairly clear quite often, but the facts will not be, and that this will pose formidable challenges. And Beth has drawn some very important conclusions from that already. Una, perhaps you would like
I'll just say a very brief word, which is, I think this is an area in which there's been some really interesting evolution of state practice. So you've seen this evolution of collective attribution by states working together, sort of coordinated attribution of cyber events to particular states. And that's beginning to, I think, evolve our kind of understanding of what constitutes attribution, what kinds of evidence is sufficient. I think the challenges here are rife, though, and I think that's why Noah's pointed to this question. Not only the challenges of actually identifying a state, because there are many ways in which states can and actors can mask their actual origin, but for many states to have sophisticated information, they have their own, the reason that they know is because they either have their own malware embedded somewhere, or because they have certain kinds of techniques that they don't necessarily want to disclose. And this has become something of a challenge because there's these attribution statements with not a whole lot of evidence, and then challenges to that attribution because the evidence is not necessarily there, and then states resisting providing the evidence that one might feel is necessary because it means blowing a resource or exposing their own actions in ways that that they may not want to. And I think we haven't really seen that fully work its way out yet. I think it will begin to, and I think it has begun to, but it does remain a very distinctive challenge. Not so much, I think, for the reasons people used to think, because we don't know who did it. I think in many cases we know who did it, or we have lots of good reason to know. We have lots of good evidence about who we think did it, but more so because those who do know can't really explain to the rest of us why, because they don't want to disclose the information that has given them that that. And that's going to become a problem as we get to court cases, we get to establishing attribution in court. That I think is going to be a special challenge that we're going to face.
Thanks a lot. I will not just to flag that our colleague from the French mission has asked a similar question on attribution. So I hope that was the answer to that was also captured in this. The next question we have is on an issue that also was a big part of the discussions in the council. It's on complementarity. It comes from our colleagues from Mexico, and the question is, how will the principle of complementarity operate in these cases, as many countries are still constructing relevant regulations on these matters domestically? Of course, a very, very central question. Maybe back to the council members on this, because it's pretty much clearly addressed to those who have worked on the report. Ona, you want to go first?
Well, I'll primarily leave it to Klaus. I mean, I think this is going to be a real challenge. In the United States, we do have the Computer Fraud and Abuse Act, which generally speaking does give us a pretty blunt tool to go after most violations domestically. We don't have a crime against humanity. So to the extent that this expands the crimes, the crime against humanity, that would be an issue. Obviously, the US is not a party to the ICC, but thinking to other countries that are facing similar kinds of challenges, I do think that it is going to cause, it ought to cause states to go back and look at their statutes and see if they're sufficiently covered as we understand, as our understanding becomes more fine-grained and more clear about the kind of possible application of the Rome Statute. I do think it should occasion states to go back and look to see whether their existing criminal laws are sufficient to give them jurisdiction over these kinds of crimes, and if not, to make amendments. And that is consistent with our view that states have an obligation of due diligence to address the problems at home. So there is a kind of nice coincidence between the due diligence principle that is seen as applicable in the cyber context and the complementarity principle, which have this kind of fundamental underlying kind of synchronicity that I think is positive, and hopefully will lead to more states being able to address these problems at home.
Thank you so much. Klaus. I think you're muted, Klaus.
Christian, nothing on this one. I thought it was perfect what Ona said. I have nothing substantial to add. Okay,
let's go to our next question from the mission of Costa Rica, and that's on the question of evidence gathering. A little bit related, I guess, to attribution in a way. Have you contemplated that there could be extra challenge for the prosecutor to gather information for cyber attacks? Ona, Klaus?
I see Ona nodding already.
Yeah, go ahead.
What I will say is that the expansion to this space does mean that there's probably going to have to be technical capacity built internally within the court, because this is the sort of thing that is going to be difficult to gather evidence on if you don't have people who are specialists, and that's just the reality of it. So I do think that is one of the implications of this, that there is going to have to be personnel who can read and understand and interpret the code and understand what's going on, as we're dealing with in all walks of life. Every US agency has to have its own cyber experts to be able to better understand and interpret how these rules apply to the work that they're doing. And I think that one thing, hopefully, that this report does is it signals to the court that it's going to have to begin developing some of that expertise internally as well. I think that's just it's just a matter of time before that happens.
Thank you, Ona. Klaus, anything to add on to that? Okay.
I'll just add one.
Yeah, Beth, yes, please,
okay.
Of course.
The Office of the Prosecutor in particular has started to focus on digital evidence more generally, open source investigations, et cetera. And the Berkeley Human Rights Center sort of ran a process to help inform that out here in Silicon Valley, where so much of this has originated. So I think at least the Office of the Prosecutor has started down that path already, but I completely agree with Ona in that this is really a type of investigation of a different order, and you need very specialized forensic ability to do it. And that's something where I think the ASP really should invest in this area when it comes to just developing the skill set of the court in terms of the judges as well.
Absolutely. Thanks so much. Very, very relevant comment, Beth. Thanks a lot. We have a question on the meaning of armed attack with respect to 8 bis in the Rome Statute, which takes us, of course, more to Kampala than to the Council of Advisors in a way, but of course it has a particular relevance in the context of this. So it's from our colleagues from Chile. So I'm certainly very happy to refer to the travaux préparatoire of the Kampala conference and the commentaries thereon, but I'm also very happy on this to maybe go to you first, Klaus, if you want to add something in the context of this discussion.
So Christian, the question was how the concept of armed attack as included in Article 51 relates to the definition in Article 8 bis, or is that the question?
I'll just read the question. Is there any information or discussion in the report on the positions of states on what is the meaning of armed attack when negotiating the Article 8 bis? So that is the question posed. So
yeah, I think Ona has made the key point already in responding to Beth's observation. Beth has, I think correctly, she has obviously read the report already very carefully. She has correctly observed that the concept of armed attack is not at the center stage of this report. It is mentioned on several occasions. There is, for example, for every attentive reader, it is perceptible that there was, to put it mildly, a certain caution among our group to hastily concur with this idea that the concepts of use of force and armed attack could be identical. There will be much more visible a tendency in favor of the jurisprudence of the ICJ to distinguish between the concepts of use of force and armed attack. But the key point is that armed attack, perhaps surprisingly to somebody who comes to this topic afresh, that the concept of armed attack in its legal technical sense is not key to the understanding of Article 8 bis. What is important, so to speak, as a basic element is the concept of use of force. There can be no crime of aggression without an unlawful state use of force. And then there is the second concept, act of aggression. But again, this concept of act of aggression is not identical with the concept of armed attack. The concept, as the audience will know, the concept of act of aggression comes from Article 39, was elaborated upon in Resolution 3314. That was the key point of reference which states have decided to adopt. And that was a very deliberate choice. Beth, and of course, Christian, you will recall very clearly that there have been a number of candidates as those long negotiations evolved to which to refer when describing what I call the state conduct element of this definition. And one candidate was armed attack. But then, as with other alternatives, like the old concept of war of aggression, there was simply no consensus around this concept of armed attack. And so it has not been adopted. Instead, the concept of act of aggression became centerpiece, and not just act of aggression, but act of aggression then coupled with this threshold that we have mentioned. And therefore, I think one must be quite cautious from drawing inferences from the negotiations on the current debates revolving around the notion of armed attack. And therefore, we as advisors have not seen it as our main mission to go in at any length with all those controversies, which could have brought us to a completely different avenue. Our mission was to make as clear as possible how this definition, Article 8 bis, relates to cyber operations. And to that purpose, it was not necessary to give an exhaustive answer to all the interpretational problems currently revolving around armed attack, Christian. And Ona, I hope that broadly captures our thinking, yes.
Terrific. You got a thumbs up from Ona, and we're not running out of time. We've gone over time already, but I want to give the last question to the panel, and that is from Jimena Viveros, without affiliation, unfortunately, but I'll give the question to the panel. So how do panelists see potential analogies of cyber operations with crimes committed through other emerging technologies, such as artificial intelligence and autonomous weapons? Anyone, including non-panelists?
Let me perhaps say one sentence, and then Beth and Ona will have more to say. Probably, Christian, this is the very gentle invitation to organize the next group of advisors. I think it is a very intelligent question because there are obvious analogies of the problem. New technology, perhaps in a sense, it is one step further, even if we think in terms of technological steps of evolution. I think getting back to Beth's important point on Article 22, on which I now do not have the time to elaborate, but she made a very important point here. Similar questions in terms of structure will evolve here. It is probably, that's my sentiment, that in view of this context to which I've highlighted, Tallinn, work of the governmental groups, states coming out with individual position papers, and hopefully also our modest contribution here, that we have perhaps moved already quite a bit of way in terms of cyber, where we still need to catch up when it comes to artificial intelligence, but very, to a certain extent, on an abstract level, similar questions might arise here.
Thank you.
I'll just add, I agree completely. And I think this is the longstanding challenge that international law has always faced. You have technological innovation, and then we have to do the hard work of figuring out how the law applies to these new technical situations. And I think that we've learned a lot from going through this process with cyber, and we've made some decisions or come to some conclusions that I think will be helpful when we face the next set of challenges. For instance, that armed is not limited to sort of conventional arms. That then opens the door to thinking about the question of, well, how about these other technologies and how might they apply? But this is the age-old challenge that lawyers have always faced, and we're facing it together now, and we'll continue to face it in the future.
Thank you so much. Ona, Beth, anything from you on this? Okay. Noah contributed in the chat box. He said aggression is a leadership crime and would likely capture AI as well. Thanks for that, Noah. And with this, we're coming to an end of this really fascinating discussion. I think it has given many of you probably just the first glimpse of this. I have to say, at a personal level, this has been one of my favorite projects over the past 2 years, and I think the discussion today makes it very easy to understand why that is, because the questions discussed here are both simply intellectually fascinating and challenging, and so obviously enormously important. And I really appreciate the presence of everybody. I hope we got the interest of a first audience for this. We will have a good number of events on this, as I highlight certainly the formal launch of the report and the framework of the ILC. We will certainly be doing a side event on the margins of the ASP in December, and this will also be discussed elsewhere. So many thanks to everybody. Very special thanks to our panelists, and especially you, Sylvia. It's great to have you here, and thank you so much for making time. Good to see you all.
Bye, everybody.
Bye-bye.